Can we start?
Yeah.
Okay. Hi. Hello, everyone. Thank you very much for joining. My name is Kendista Wantah. I'm a counsel at SIAC. And welcome to the SIAC webinar series. This is the very first session in the whole series of webinar. And the topic today is minimizing the impact of COVID-19 on arbitrations. A very quick introduction. I'm sure many of us are wondering how we could continue with arbitration in these very challenging times, with all the travel restrictions, movement orders, quarantine requirements, events on limits on in-person events as well as on business operations. So I think this webinar is very timely and very important. Issues that will be discussed starting from, for example, which stages of arbitration could be potentially impacted by COVID-19 and what are the potential issues as well as solutions to those issues. So these are the broad points that will be covered among others. If you have any questions, please feel free to type it in using the Q&A function on the bottom of your screen. Grateful if you could also mention to which speakers the question is directed to. I think we will try to address it either as we go or to follow up with you afterwards. By the way, you can also use the raise your hand function on Zoom, in which case I suppose we would try to unmute you so that you can ask the question verbally to the speakers. Okay, so I think let me start by first introducing our very distinguished speakers. None of them require introduction at all, actually, because I'm sure you already know them by reputation and perhaps in person as well. The first one is Professor Lawrence Bu. Professor Bu is one of the founding voices of arbitration in Singapore. He is a member of the SIAC Court of Arbitration and was the Deputy Chairman, first CEO, and Registrar of SIAC. Presently, Professor Bu heads the arbitration chambers in Singapore and has sat in approximately 300 cases as arbitrator. Professor Bu is also very active as an academia, having published extensively, and is also teaching at the National University of Singapore and Bond University, Australia. Our next speaker is Mr. Toby Landau QC, who is also a member of the SIAC Court. Mr. Landau has been a barrister and arbitrator in Essex Court Chambers since 1994 and has acted as arbitrator and lead counsel in hundreds of arbitrations worldwide, both investor state as well as commercial arbitrations, and not to mention acted as lead counsel in many landmark cases in court. Mr. Landau is visiting professor at King's College London, UK delegate to the UNCITRAL Working Group for 20 years, and a draftsman of many arbitration legislations in the world, including the English Arbitration Act 1996. In 2012, Mr. Landau was appointed to the panel of advisors of the Attorney General of Singapore. The third speaker in this session is Mr. Chong Yee Leong, who is a member of the SIAC Board of Directors. Mr. Chong is co-head of Allen & Gledhill's International Arbitration Practice and head of the firm's restructuring and insolvency practice. He has been active in law for nearly 30 years now and is recognized as a leading international dispute resolution practitioner in Asia Pacific. In 2018, Mr. Chong was one of the select practitioners recognized as a senior accredited specialist in building and construction law by the Singapore Academy of Law. And last but not least, Mr. Alastair Henderson, who is the managing partner of Herbert Freehills in Singapore and head of HSF's dispute resolution practice in Southeast Asia. Mr. Henderson has been in the region since 1999, having practiced previously in London, and is recognized as one of the leading names on the Asia Pacific arbitration scene. He represents numerous clients as counsel before tribunals all over the world, and is also appointed regularly as arbitrator in major centers, including SIAC. Thank you all very much for being here. It truly is a great privilege to be able to hear your thoughts and issues on the topic today. So with your indulgence, perhaps I could move on with the discussion right away. The speakers will not be making any presentation today. What we're going to do is I will be asking a question to two speakers or all speakers regarding a particular issue. And then we can perhaps discuss it even further before moving on to the next issue. And so on until the whole session is over. Okay, so the first question, the first issue is concerning commencement of arbitration. So many have quite sensibly forecasted that the COVID-19 outbreak will cause many commercial delays or cancellations because of disruptions in, for example, construction, manufacturing of goods, and provision of services. So defaults in commercial transactions appear imminent, and people may want to seek enforcement of their rights, including, among others, by way of arbitration. But then, as we all know, arbitration is also impacted by COVID-19. And this crisis seems quite enduring and may continue for some time. So in this kind of circumstances, I would like to seek your views if you see any strategic advantage or perhaps disadvantage in commencing an arbitration during these times. Mr. Landau, could we perhaps have your thoughts on this?
Yes, indeed. Thank you for the question. I think there are obviously a number of different types of consideration when one is thinking about whether to commence an arbitration at this stage now or not. The first point to make is, of course, one of uncertainty. All of this is new territory for everyone, and it is entirely unclear how it is going to develop. We don't know yet whether we're talking about months. We don't know whether we're talking about years. And so the situation is one of absolute flux. And that often is a situation which militates against taking any particular strategic decision until one knows how things are going to pan out. In terms of the substance of the likely disputes that will arise, and of course there will be many, many different types of disputes, one can't give very concrete advice yet either. One of the classic points would be, has there been frustration of a contract? Has there been force majeure? And actually, we may not know yet because the situation is still fast evolving. So crystallizing a substantive case is actually quite difficult at the time for now. And maybe in a year's time or 6 months, that will become clearer. But in terms of the actual procedural question, if one has a claim, should one now commence an arbitration? I think there are really two different sides of the scales. On the one side, there's a question whether one needs to commence. Of course, there may be a commercial imperative to begin now because of some commercial disaster, some need for compensation, a need for urgent relief. As against that, there is the consideration about starting an arbitration which may itself procedurally be tainted, or it may be compromised because it is being started in this unusual setting. And really, to me, there are two elements to this. The first one is sheer practicality. Are you going to be able to get instructions? Are you going to be able to access documents, to actually interview witnesses sufficiently to be able to put together, practically speaking, a case? And then, of course, the logistical difficulties of then proceeding with that case, which no doubt we'll come to, as to how the arbitration practically might proceed itself. That's the first one, practical considerations. The second one are legal considerations. Will there be possibly objections that the other side could raise now of due process? Will they be able to taint the process by saying, well, we can't respond properly because of lockdowns, because of curfews, because of logistical difficulties? And that depends upon looking at what are the standards at the place of arbitration, the seat, the lex arbitri, and also, of course, at any likely place where there may be recognition and enforcement. Because at the end of the day, it serves no one to start an arbitration if ultimately an award will not be recognized or enforced because of due process concerns. So that is those are really it's a list of the considerations, I think, that everybody thinking about commencing an arbitration now would have to go through.
Thank you very much, Mr. Landau. Mr. Henderson, could we perhaps get your comments as well on this?
Thanks, Kendista. Look, I think you can always think of a good example of how it might be strategically helpful or strategically unhelpful to start an arbitration in this time of the virus. I guess, for example, if you have some complex project dispute and you, the claimant, happen to be very much on top of your documents, very well versed in all of the technical issues, absolutely able to present a complete and comprehensive, well put together technical claim, then maybe it would be strategically advantageous to start now, knowing that your counterparty is going to find it that much harder to pull together their technical case when all of their people and their documents and their lawyers and their experts are separated and segregated. So you could make an example, but generally speaking, completely accepting everything that Toby's just said just now, which I think was important and helpful, it seems to me that the virus and the shutdown associated with that will of course be a consideration, but only one consideration, and possibly not even the greatest consideration in all of the different factors one takes into account in starting an arbitration or deciding when to start an arbitration. And my sense is that even if a respondent was to say they're very prejudiced in putting together a defense to a claim that had been opportunistically started against them, knowing that they would struggle, then tribunals will probably be sympathetic to that in setting their timetables. Let me say that I started a case in SIAC last week with the team. We filed the case, you guys dealt with it, you've issued the correspondence, the case is on its way, and it might as well have been during ordinary times. I haven't seen any difference in the starting of the case due to the lockdown, the circuit breaker here in Singapore.
I see. Thank you very much, Mr. Henderson and Mr. Landau. Thank you both. This is very, very interesting.
Ken, sorry, if I may just add on to what Toby and Alastair have said.
Please
frankly,
do,
I think
Chong.
yeah, sure. This COVID situation and the lockdown, frankly, I don't think it's going to be like a momentary or something that's going to go by and then we'll forget about it in maybe 6 months down the road. I think it has fundamentally changed the way we are going to work, fundamentally changed the way that we are working. And you will see more and more, frankly, I think, people working apart from each other. If you look at the prognosis, even the most optimistic ones will tell you that the vaccine won't be available until next year. But life have to go on, and I think we will have to continue working the way we are now. And as Alastair said, if someone filed an arbitration today, I don't think it's any different from normal times or COVID times. Communications will continue. People will continue to prepare their documents, prepare their way they carry out things. So frankly, I don't think it will prevent the dispute resolution from going on, but if people will just have to work in a different way to make sure that we carry on life as normal as possible. That's how I will see it.
So it seems that this whole COVID-19 situation may, in a way, force us to transition, to change, and move on to the next phase in terms of dealing with things, including dispute resolution processes. Professor Boo, before,
yes.
Do you have any comments?
Yes, I do actually. Thank you. I was thinking that any party who is thinking of commencing action as a result of breaches occurring during this period must be also very conscious of the acts of frustration, the statutes of frustration, I mean, acts of parliament that are being passed by different countries, freezing or causing a pause to any cause of action that might have occurred in this process, during this period. And so anyone jumping onto wanting to call breach and seeking relief at this time must be conscious of that. Not only in Singapore, in different countries, they are enacting laws. I think Scandinavian countries were the first to start. And it's going to gain momentum. More and more countries will enact laws to freeze or pause this moment. So I don't think we should get too excited. if you're a lawyer waiting to jump on the bandwagon to shoot first, be careful of that. And as you say, observed by Yee Leong, it may not be for a short period, maybe longer than 6 months, but for how long this frustration acts or frustration statute is going to be enforced, we don't know. At the moment, 6 months, but it may be longer. But in terms of the commencing, you asked about whether there's an advantage in commencing arbitration. I'm not sure whether there's an advantage or disadvantage. I think life goes on in terms of commencement process, like what Alastair was sharing, remains the same. In fact, this last 2 weeks, I got 3 cases that have been commenced that by the appointing process. So I think things are going on as per normal for previous cases, for previous cause of action, breaches. But during this period, I'm not sure that whether it's going to engender a lot more cases for lawyers, if that's what we're looking at.
I see. Thank you very much, Prof. So it seems like it's business as usual then, notwithstanding the whole situation.
For the time being.
At least for the time being.
As we get into if it's too long, things may change, I think. There'll be a new normal, perhaps.
Okay. It's also interesting that Mr. Landau mentioned about, I think you touched a little bit on stages of arbitration that might be impacted by the COVID-19. So I would like to explore this issue as well. So beyond commencement of arbitration. In terms of stages, it seems that in-person hearings are also affected because of, in-person hearings would require parties and or tribunal to travel from to travel and gather at the same location. But in addition to in-person hearings, could you perhaps help identify which specific stages of arbitration could be potentially impacted by COVID-19? And what can the tribunal and parties do to help ensure that those stages could proceed as safely and smoothly as possible? Maybe we could have everyone's views as well on this. Mr. Henderson, would you like to start?
Yeah, look, I'm already seeing this impacting most stages of cases, certainly hearings, but also earlier stages. If we say that very broadly, a typical arbitration in an old-fashioned, in a traditional procedure, will have a written submission stage followed by a document stage followed by a witness stage. I'm seeing at all of those stages parties raising arguments that they're being held back or delayed by an inability to talk to their clients, to their witnesses, to access their documents or their experts. And of course, on the other side, you're seeing people saying this shouldn't make a difference, there should be no impact on the timetable. Everybody always has their own view on how the timetable should proceed. But if the question is, does it impact other stages of the case beyond simply the hearing, then yes, certainly, and not just in theory, but in practice already. What can tribunals do about that? Well, tribunals always have a duty to ensure that the hearing and the procedure is fair and that parties have an opportunity to present their case, an opportunity to be heard. But at the same time, tribunals need to be robust in making sure that cases don't drift and aren't delayed unnecessarily. And the best way that tribunals can discharge all of those duties is by being completely on top of the facts and knowing what the issues require evidentially and having a sense of how long is needed so that they can make the correct judgment in all the circumstances.
Thank you, Mr. Henderson. Mr. Landau, do you have any comments on this question?
Yes, I think it's right that, as Alastair said, actually every stage may be impacted by the current situation, from commencement to liaising with your clients, to taking instructions, to putting together a case. I mean, I'm finding that at the moment. I have ongoing cases at the moment where ideally I would be meeting with witnesses, I'd be meeting with clients, I'd be looking at documents, and everybody is under a respective restraint that makes that a very different kind of exercise. Not to say that it's impossible, but it's very different. And as one goes through the chronology of an arbitration, the impact will be there all the way through to the way tribunals deliberate, all the way through to how do you sign an award under various governing laws at the moment and issue it when you sometimes have to do that in person and at the moment you can't. So There are issues all the way through, but what to do about it? What we have to remember is that actually it's arbitration that should be leading the way here in finding flexible, ingenious innovations and solutions, because we are running supposedly one of the most flexible systems of dispute resolution. And what we've got to be very careful of is that we're not outdone by national courts, because many national courts are proceeding almost as normal, albeit with remote technology. The Singapore court's been doing it, the English court's been doing it, and I understand that next week, of all the sort of what the least techie courts one can think of, the United States Supreme Court will have remote hearings. It will put us all to shame if we can't do the same. And actually, the truth is that in arbitration, we have been innovating for many years. There are many ways in which things can be done differently from a conventional style. And what I'd say about that, just very briefly, is that we already have, in the short time, relatively short time that we've been in this new normal, we already have a whole range of guidelines that have been published about steps to take and protocols and norms to follow. Whether it's, I'm not sure I'm allowed to mention it without being deleted from this webinar, but even the ICC, which I understand also has some arbitrations, has issued a guidance note on how to deal with the situation. We have a Chartered Institute of Arbitrators guidance note. We've got the Seoul Protocol on video conferencing. We've got an ICSID online guide. And even going back before the virus, we've got the Hague Conference draft guide on good practice using video links, which is of March 2019. So there's an awful lot of learning out there already, a lot of standards that can be used. And I think just to round this off, what I think will come out of this is, if we want to say, how do we mitigate these effects? How do we actually solve these problems? If we looked to the true nature of arbitration, it's now incumbent upon parties, counsel, and tribunals in particular, to really proactively case manage. That is not to sit back on automatic procedural order number 1, which applied in pre-virus days, but to think about what is really needed for each dispute. Maybe now to bifurcate and have preliminary issues more often than one might otherwise, to narrow issues, to try and use experts differently, maybe tribunal appointed experts, to try and think of limiting the scale of written submissions. All of these, there are many different possibilities. Now is the time that tribunals should be doing that in order to actually make the process less cumbersome and easier to handle remotely.
Thank you very much, Mr. Landau. Professor Bru, do you have any additional comments on this or your own views?
Thank you, I do. I think from the lawyer's point of view, I mean, for counsel, I think there's more difficulty for counsel, more challenges for counsel in preparing the case, meeting clients. The disclosure process, for example, can be very tedious and cumbersome in arbitration, and during this period, all the more challenging. So I can imagine the difficulty counsel and solicitors representing parties are undergoing. So, but from the side of the tribunal, I must say that it is less challenging. In fact, it gives more the tribunal can be more flexible, can be able to give more flexible timelines, and I think I agree fully with Toby that this is a time for institutions and for arbitrations to lead the way in innovation. We do not always need to have experts on everything. Experts, for example, a lot of them, technical data can be done truly by models, by engineering models, by algorithm models that can generate options for the tribunal. There are a lot of things that can be done. And I'm not sure about tribunal appointed experts, so I have my own views about tribunal, single expert appointed by a tribunal, where there's no test other than the tribunal itself or counsel. So that's for another day. But I think this is a time for us to really innovate and be bold to try new things. I mean, like this webinar and the use of Zoom and Blue Jeans or whatever technology that's available for video conference is fantastic. Without this push by the virus, actually, many of us will probably not be doing what we're doing now. We'll be trying to sign up and register and attending attend a physical meeting, right? So this is wonderful to have so many people online. I can see that there are 465 people right now listening to us or participating in this, this seminar. It's fantastic. And I think there's great opportunity for us to try new things without fear that it will not going to work. We are just at the beginning, at the cusp of something new. So it is something that I think is exciting. We should grab the opportunity. And there will be problems. There will be, tribunal may not be as comfortable using technology, but it's really a matter of getting them used to it. You know, it's just try our hands. It'll work, it'll work.
Yes, thank you for the inputs and optimism, Professor Bu. I also share that view, and I think there could be hiccups here and there in terms of the transitional process, but I think this may lead to something good as well. And obviously, cost can be reduced because of the use of technology and everything. So it's actually a very it's quite an exciting moment if you see it from a different angle.
And if I may also add, for the institution, maybe something should be done about documenting the whole process. Electronic documentation rather than hard copies, really got to transit from that already, you know, and have a case management depository available like ICSID, LCIA. They're doing the SIAC hasn't got that yet. Maybe something to be done there.
Thank you very much, Prof. Thank you very much for the input. Mr. Chong, before we move on to the next issue, would you have any thoughts to share for this one?
Yes, I do actually. I absolutely agree with what Lawrence have said, and particularly also what Toby have said about trying to make the process more efficient. I think now is really a good time for arbitration to shine and to show the flexibility and the ability for us to innovate. Now, for a long time, arbitration has got into a very comfortable mode, you know, like procedural order number one and everything. Everyone goes along that and nobody give a second thought about how one proceeds. But now is a good time for us really to make the process more efficient, like cutting down the process into small bite size so that we can deal with it very efficiently. And then you do not wait for everything to end in one major merit hearing where it becomes very cumbersome and people have to cater for all sorts of possibilities. Instead, now if you put into bite size and you cut it into portions that you can deal with, and it becomes a lot more efficient and a lot more cost effective. This is the time for us to show what arbitration can do. And I think we all have to change our mindset. Mindset is actually very important. We have to switch from old-fashioned hard copy to electronic digital copy. We got to be comfortable dealing with people through the computers, through the net, and we got to be comfortable with conducting hearings, submissions, particularly through the computer. And I think all of us here are common lawyers, and we are always very, very fussy about cross-examination and cross-examining our witnesses in person and eyeball them and make them nervous. I think that's something that's going to change pretty soon as well. And that's a process that I think all of us have to undergo. And this pandemic is going to change, like I said earlier on, the whole way we're going to work, even after the pandemic is long gone.
Thank you very much, Mr. Chong. I see we are starting to get some questions from the audience, but perhaps before we turn to the audience, we could discuss one more issues. I would like to discuss about procedural tools that are available in institutional arbitration. For example, at SIAC, we have expedited procedure and features like early dismissal of claims and defenses. This tool, as you know, could save significant cost and time, but then in view of the current unpredictability brought by the COVID-19, do you think users should still consider using these procedural tools? Maybe we could get Mr. Chong's view on this.
I think these procedural tools are going to be even more important during this time. If you look at the expedited procedures, I think that is going to be even more important. If you have cases that are suitable for that, for documents only, or even cases that can be resolved within a very short couple of days kind of hearing, that would be ideal for this period where we've got to make things as quick and as efficient as possible. Just like early dismissal, those are things that can be conducted without really having to hear witnesses, purely by submissions and by documentations. Those will be actually very ideal for this kind of situation.
Thank you. Mr. Landau, do you have any views on the use of procedural tools at institutional arbitration as well?
I think this leads on from what we've already discussed, and I completely agree with Yee Leong, his view on this, because one can see this as a positive. This is a situation where one should be looking for more streamlined processes, which are actually more feasible given the restraints that we have, and mechanisms such as expedited procedures and as early dismissal of claims or defenses are ideal in that way. What it requires, however, is perhaps everybody buying into the idea that the arbitration process has got to be reconfigured in order to adjust to what is our new normal. So people come with procedural expectations that they will have not only a reasonable opportunity to bring their case, but a full opportunity. And that means that they want all the elaboration that they would normally have in the old pre-viral days. They want to have full submissions. They feel they have a right to full hearings. They have a right for every issue to be ventilated. And actually, that's just got to be recalibrated. And maybe that's going back to the heart of arbitration. In the end, we will then, I think we'll develop a new jurisprudence on what a reasonable hearing means. And if there are more limitations as to what is possible, that will narrow what is reasonable and what is to be expected. And once everybody's expectations have been recalibrated, then we may see much, much more use of simplified, streamlined procedures. But of course, there is a note of caution, which is until everybody has arrived at the same landing of redefined expectations, the risk will be due process objections. And that goes back to a point that I made at the outset. For all the optimism, which I do share, one's got to be measured, because there's no point going gung-ho into this until everything has settled a little bit and simply ending up with lots of challenges in court, whether that's at the seat of arbitration or attempts to defeat awards at recognition and enforcement. That will all be self-defeating if that happens, if we allow that to happen. So I think the process has got to be step by step, and it will settle hopefully over the coming months or perhaps a year or so. But we will have to wait and see. And I think it's also difficult to generalize because the nature of the lockdowns in different countries are different. I have got cases at the moment where I'm dealing with other countries where there is an absolute curfew and where people are not allowed to leave their premises at all. And that actually may mean they simply cannot go to retrieve documents which they don't have electronically. That's a situation which one can't just brush over with optimism. That's a situation where actually genuinely there may be difficulties in defending or prosecuting a claim. And so all of those have got to be factored in with an overall balancing.
Thank you, Mr. Landau. You mentioned about due process, and I would like to get back to this as well, because from one angle, I think there is also a concern that the whole COVID-19 situation can be used as an unnecessary, to unnecessarily delay proceedings. But before we get to that, perhaps we could look at, there are already questions lining up. I see one from Vikas Mahendra. The question is to Mr. Henderson, who is the ex-boss. Question being, are you seeing in practice a more fundamental shift due to the pandemic to bring about cost and time efficiencies along overdue arbitration beyond just video conferencing? For instance, the use of virtual rooms, online arbitration institutions, online transcription, audio, video recording, screen sharing documents, doing away with hard copies, and so on and so on. Mr. Henderson?
Thanks, Kendista, and thanks, Vikas. It's good to hear from you. Look, I was thinking while I was listening to the comments that have gone before, all of which I think were very important and valid, that this is a debate that we've had many times about how arbitration can be improved, how the time, the cost, the procedure of arbitration can be updated, brought into the 21st century to avoid some of the issues that arbitration has suffered in years gone by. Definitely, the experience of COVID-19 will contribute to that debate. Definitely, it will push that debate forward, and definitely it will encourage us to explore new options. I don't think it will be the cause of a transformative change, but it will be an important driver along the road that we're already embarking on to make us think, as Lawrence Boo was saying, you know, for example, about the use of Zoom or other technologies, to force people to think more about virtual hearings and electronic filings and entirely electronic documents in arbitration. All of these things are happening now. I'm sure all of us on the call and most of us listening have conducted arbitrations that have had no hard copy paper. So it's not that this will be a new revolution, but certainly it's encouraging us to think about these things. And that's a good thing because, you know, if given the number of people all over the world who speak about the important need for innovation in arbitration and the essential importance of driving change, it's amazing it's not really happening that much or as much as it should be, given the interest that's been devoted to that. So perhaps this will be significant in actually forcing us to engage with those issues rather than just saying how important they are. I don't mean to sound cynical. I know that people have all over the world devoted a lot of time, attention, and case management to this, but it is striking how far ahead the debate is than reality. So perhaps the virus will help us bring reality forward too.
Thank you, Mr. Henderson. We still have one more Q&A that we could perhaps address at this juncture. It's to Mr. Landau from Rohit Bhattacharya. As regards the use of early dismissal, would the current COVID situation, in your opinion, constitute an exceptional circumstance for the 60-day time period for rendering an award to be extended?
So that's a very specific question because it depends. There will be, obviously there'll be cases when one can readily think that it's not exceptional because on the facts of the case, it actually hasn't impacted. And then in other cases, it may well have an impact. I think that goes back to the point I made earlier, that we should be careful about generalizing too much about the situation, because the situation is impacting differently in different jurisdictions. And also, of course, different countries are at different stages of this process, different stages of lockdown and different types of lockdown. So I think it'd be dangerous for anybody at the moment to give one all-purpose answer, I'm afraid.
Thank you, Mr. Landau. I would like to now talk more about hearings, because I think many interests of the audience are geared towards hearings. Professor Boo, would it be prudent in your views to maintain existing hearing dates? Do you think parties and tribunals should consider postponing? Because I'm sure there are already arbitrations ongoing and people have already made arrangements for hearing in that case. What's your views on this, Prof?
I would like to follow what the lawyers always say, like Toby. It depends. Yeah. If you're talking about hearing dates that are fixed during this period, in other words, during this lockdown period or circuit breaker period, whatever you call it, in whichever jurisdiction, then chances are, I think tribunal may not be able to hold, tribunal can't hold a physical meeting, but you can always go into a Zoom hearing, a virtual hearing like this and reorganize. It is possible. So it depends on whether the witnesses are available. So you see, some witnesses are in jurisdictions where they don't have internet connection, or the lawyers and the witnesses are in different places. In one case that I actually postponed, in a tribunal that we actually postponed, which was supposed to be going on actually this week, was because the witnesses, the counsel could not meet witnesses, and they are in different jurisdictions, some in places where there's just no internet connectivity. So a session like this is not possible. And you have also logistical problem of arranging everybody to be available at a certain time. And like what Toby said, in some places they're complete lockdown. They are not allowed to leave the house, period. There's no question all of any possibility of going somewhere where you can get a computer and sit before a computer. We are the privileged ones, you know. Not everyone has this capacity or ability to do it. So we have to look at the situation. So in those cases, postponement is the only thing that is possible. But of course, postponement not indefinitely. Once we have a postponement at that date, we will have to say that come that date, if we can't meet physically, we will have to have a video hearing. It has to have a finite end. Otherwise, you can't have an indefinite date for, there's no date for a hearing. It must proceed that way. So I think it really depends on what the circumstances are, because we know, as a tribunal, we know lawyers do have and witnesses do have problems in conducting a physical meeting. So I must say that during this period, most of my hearings have been postponed. The earliest that is coming on will be in May, hopefully after this period. And we are keeping our fingers crossed. If not, the default will be using a Zoom meeting. Yeah.
Thank you, Prof. Mr. Chong, do you have any thoughts that you could share regarding this?
Yeah, I think during this period, all my hearings have been postponed. The baseline, I suppose, is that everybody was expecting to have a face-to-face hearing, and people were preparing on that basis. And I think particularly those that with witnesses that you wish to cross-examine, those were the expectation of the parties. And it is going to be difficult for someone, even if we can overcome all the problems that Lawrence has talked about in terms of connectivity and people in different places. The expectation is there. And if you impose a virtual hearing, I'm worried that the problem that Toby has talked about in terms of challenges, in terms of lack of ability to present the case, all those issues will come out. And therefore, I think tribunals will be very reluctant to actually impose any virtual hearing on parties at this stage. But you know, that is there have to be a like Lawrence said, an end date to it. It cannot carry on indefinitely. And if we do move on to a stage where we find that it's going to be impossible to carry on with a face-to-face hearing, then alternative arrangement will have to be made. And that's something that actually I'm facing at the moment as well, because I actually had a hearing this week in Spain, but it cannot be carried out, obviously. And we have now postponed it to July. I'm not sure whether July is going to be feasible. Then the next alternative date we have also booked just in case for September. So, well, I think parties are trying to make alternative arrangement, but eventually, if this thing doesn't clear up, and then we will have to be a bit more innovative about that.
Thank you, Mr. Chong. So I guess we're talking about virtual hearings as well. And I think as has been mentioned as well, there are a number of issues that are floating around the idea of virtual hearings, and I would like to get your views on this. First, do you think virtual hearings could impact the effectiveness of oral arguments? If so, what kind of measures could be taken to prevent or minimize the issue? Mr. Chong, can we have your thoughts on this issue as well?
I think if you talk about submissions, you talk about counsel submissions. Nowadays, a lot of submissions are actually made in writing, and most of the time, by the time the counsel comes before the tribunal, the written arguments will have been delivered to the tribunal, and the tribunal will have read the arguments. So it's the time usually is spent clarifying any ambiguity or allowing counsel to emphasize or to make certain points that they feel have not been emphasized sufficiently in the written documents. So I don't really think a Zoom hearing or virtual hearing actually degrade those kind of submissions. And in fact, I've done submissions not in Zoom, but just on telephone audio without video, and I find that actually sufficiently effective for parties for counsel to be understood, and for tribunal to really get the gist of the argument. I think the difficulty really comes when one has witnesses, and sometimes it is not easy to try to examine a witness via video conference or via a Zoom, because sometimes you do need the body language. You do need to read the body language. You need to understand the context in which someone is making a statement, and that actually, to me, poses the greatest difficulty in terms of a virtual hearing.
Thank you, Mr. Chong. Mr. Landau, could we have your thoughts on the issue of, it would be disadvantageous for a cross-examiner to examine a witness via video conference because of the, reading the body language and everything, like Mr. Chong said?
I think all these concerns are overstated, and I think that they are generated by a romantic vision of what cross-examination is. People think cross-examination is going to be this high-pressure exercise where everybody will be looking at every physical twitch and movement of the witness, and ultimately huge pressure will come to bear and they will buckle and cry and admit everything. And those cases happen, but they're not that often, not that frequent. Very often cross-examination is not about that. It's actually about trawling through documents. And I think those sort of exercises are done just as well by remote means as in person. In fact, I personally, I've done many hearings cross-examining witnesses. And I actually think that at the moment, curiously, the way that we operate with this sort of technology, with Zoom or with all the other similar platforms, as a tribunal and also as counsel, you get a closer up vision of somebody's face than you do in a hearing room. It's true, it's not the same sort of direct eyeballing that might happen during a cross-examination, but you can see enough. And I think if the witness is being evasive or is being arrogant or is showing discomfort, that will come over clearly through remote means as it would in the room itself. One only has to think about what politicians look like when they are being interviewed on television to know that it is possible to detect evasion and arrogance even at a distance. So I think these things, well, again, it's a question of recalibrating expectations. I think it's something that we will all get used to, and I don't see any particular problems. Where issues come, I think, are more just practical questions. And these are issues which are being well worked out now, but they're important. Things like making sure that everybody has the same access to the same documents, which sometimes is more difficult if you are not in the same room. Making sure that issues of translation or interpretation are resolved, because again, that's more complicated if you're not in the same room. Issues of technological issues, essentially, shared screens, using demonstratives. But all of that, again, we are learning fast at the moment, and there are heavy trials that are happening now, happening before courts, heavy cases before arbitrations, and they're happening remotely without any real difficulty. So I think we just have to rethink the process, and I have no doubt that this will become the new normal.
Thank you, Mr. Landau. Mr. Henderson, do you have thoughts on this issue as well?
Yeah, look, I don't think oral argument should suffer significantly by being conducted virtually. And I think the best demonstrative of that is how many procedural hearings now take place already by telephone or by video conference. If you have 2 counsel or 4 counsel or however many counsel making submissions and conducting oral arguments, I see no reason why that can't be conducted in the vast majority of cases as well by telephone or video conference as face-to-face. And I don't think the virus will significantly change that. It's already happening in many international arbitrations. As regards final hearings and witness hearings, I agree with Toby. I don't think, in principle, that it is significantly disadvantageous to cross-examine witnesses over a screen. I've done that, and I felt it went as well as could be hoped. I've had witnesses appear in front of me as an arbitrator, over a screen, and I've found that that has been perfectly satisfactory in terms of understanding their evidence and getting a sense of the witness. I do think there are significant issues with virtual hearings, but they don't go to the reliability of the cross-examination, except perhaps where there are issues around allegations of, well, I have a case at the moment where there are allegations of bad faith and conspiracy and so forth. And those kinds of issues perhaps do need to have face-to-face cross-examination, but as much and perhaps more is the technological challenge. A lot of international arbitrations these days have parties and counsel and tribunal members from all across the world, and trying to get simultaneous presence in an effective way on screen with 10 separate locations in 5 separate cities across the world, maybe separated by a 10-hour time zone spread, and then allowing for translation and the availability of documents. That, I think, is a very significant challenge still, and that, I think, is one of the reasons why, at least in my experience so far, a number of hearings are being adjourned. I think you may come on to asking us about the online case management systems, and they're good but not great in my experience so far. One thing I would say is, I think part of the question was, should we be talking to arbitrators about this or something to that effect? The answer is most definitely yes, because hearings are being adjourned now and arbitrator diaries are amazingly fast booking up through the rest of this year and well into next year. So if you have cases involving arbitrators with a number of different appointments, then you certainly should be engaging with them right now if you want to have a hearing anytime soon.
Thank you very much, Mr. Henderson. I see that questions are lining up again, but I think before we turn to the audience, perhaps we could get the speakers' views on witness coaching and virtual cross-examination. Some people have concerns that witness coaching could happen in virtual hearings, notwithstanding COVID-19, especially where the witness's credibility is key. And when we are watching news, anchors are most likely reading running text as they speak, and we generally could not tell. How would you all prevent this or any witness coaching from happening in virtual cross, where witnesses' evidence are taken remotely and without supervision of opposing counsel or anyone? Perhaps we can start from Professor Boom.
Okay. I think it's a practical issue. It's a practical issue. I think it can be easily overcome. Like what there's a sole protocol to follow if you want. But it's a practical issue, and for example, like what the people who are doing the stay-at-home orders have to comply with, there will be one officer there who will just take a photograph of a particular place or take a video of a particular place. And if a witness is being coached with and reading lines that are being sent, your cross-examiner, a skillful cross-examiner can easily fish that out and highlight that out to us very easily. And I think the tribunal is not blind to these things. We will be able to ensure that when a witness is giving evidence in a room, make sure there's nobody around, no prompters. I don't think they have teleprompters anyway. They'll screen immediate answers. It may be worse, actually, if there's any attempt to do that. It'll probably be very confusing. The poor witness will probably be all totally confused, and it will be great time for cross-examiner, skillful one like lawyers who are present here with us today. So I don't think that is a real problem to me. I've never seen that in the cases that I've done where witnesses are remote, and even without lawyers present, they are just in their own office or in their own workshop. It never happened to me, at least. I'm not sure whether these are imagined scenarios that we see in the films, but I've never had the opportunity to have to encounter any of this. Again, in terms of oral arguments, I don't see a problem. I don't think video conferencing of witnesses is a real issue. And all this to me, is still imagined. I have not seen the reality yet. Thank you.
Thank you, Professor. Mr. Chong, could we have your thoughts on this?
Yeah, I absolutely agree with Lawrence. I think this issue of witness coaching is actually somehow overstated. It's not easy, frankly, for someone who is actually being examined sitting there, okay, who have to understand the question and then formulate his thoughts and answer. And then at the same time, listening to someone else who is supposed to be sending him messages either via a teleprompter or speaking quietly next to him. It's not an easy task. And for someone to try to do that, I think it will be very obvious to whoever who is looking at him. So this witness coaching thing is not, to me, not a big issue.
Thank you, Mr. Chong. Mr. Landau, could we have your views on this as well?
I think the situation, I mean, certainly counsel's perspective so far, and this is in the pre-virus days, was one always had a concern that there may be somebody in the room who is suggesting something, pointing to documents, prompting. And so ordinarily, what one would do in the many cases that have happened where cross-examination has been conducted remotely is beforehand, by prior arrangement, you would have a representative of the other side in the room. And that's frequently done. And also just to help with documents, as you would in the hearing. So if there's not to waste time trying to find a document, you'd have somebody there just to assist, whether the document's electronic or in physical form. Whether that's still possible depends on the nature of the local lockdown. If the lockdown means that nobody can actually enter into the premises, then that's not possible. But again, these lockdowns change and the restrictions going forward may change. And so we don't know in the coming weeks what the local situation will be like. But otherwise, assuming that, that one can't actually have anybody there supervising, you can ask somebody to show their camera around the room to see what's there. But ultimately, it's quite limited how effective that's going to be, because I think the easiest way of prompting will be WhatsApp messages or instant messaging with some sort of prompt that comes on screen that nobody else is going to see, which might simply say, it's not giving you a full script, but it might simply give an indication of the way that the answer should be crafted, or a yes or a no or something. And at the moment, frankly, there's no way to stop that. And so we rest upon the good sense of tribunals to detect it or to review the overall situation, as Lawrence has said, by taking a view on it. And if we remain in this state for many months to come, no doubt the technology will improve and we will have a program that will show what is on the screen or in front of the witness, or there'll be solutions to it. But all of these, I think, are minor. They're minor concerns in the grand scheme of what we're talking about. None of this is sufficient to say that we cannot proceed remotely.
Thank you. What about you, Mr. Henderson? Do you have any views on the issue?
No, Kendista, look, given the time constraints, I agree with everything that people have said. I think it's an issue that's more talked about than experienced in reality. And if people nevertheless feel that they want to take measures to guard against it, then either putting people in the room or positioning cameras around the room, whether you send one of your own team to be present in the room, or sometimes I've seen parties mutually agree to engage a neutral third party. These are the tools that are used. Whether it's necessary, I think, is open to question, but it does seem to happen frequently.
Thank you. So I think we can turn to the audience because I see questions are being submitted. First is from Shreya Singh. It's to Professor Boo. Will there be an increase in demand, Prof, for emergency arbitration given that constitution of a tribunal and other such logistical issues become problematic?
Will there be predicting? I'm not sure. I can't predict. There will be possible. Of course, emergency arbitration is just true. Arbitrators are meant to do interim measures. So if there is a need for interim measure to be granted, hastened by the COVID-19, I can't be sure, because it could well be because we're in a pause situation. What is the use of interim measure when everything is not moving? If you want to destroy documents, you can't go to office, or you want to sell your ship, there's no market. What is there? I don't think there will be an increase. You know, I don't think so. I think because everything is in a flux, or in a pause actually. So I don't anticipate there will be any straight increase in interim measure application to emergency arbitrator. But if there is need for one, there always is. Appointing emergency arbitrator will be a very quick fix. Yeah.
Okay, another one is from Ayush Kashyap. person mentions that this is perhaps not topical to today's conversation, but what would the panelists have done had this crisis occurred at the beginning of their careers? What lessons do young lawyers learn from this? Maybe we can start with Mr. Henderson.
Thank you. I'm not sure whether that implies you think I'm the oldest person on the call.
Not at all, Mr. Henderson.
Look, I think the point has already been made that the response to this virus is going to be innovation, and it needs to be innovation in all forms of arbitration procedure, in the way we conduct cases and in the way we conclude cases. And young lawyers are probably going to be that much more savvy and in touch with opportunities of modern technology. I know my children are about 400 miles ahead of me in understanding how to use modern technology. And if we apply that across the legal profession, then I encourage young lawyers to be as innovative and imaginative as you can be in trying to rethink what arbitration might look like in the 21st century without all the baggage that the rest of us are carrying around. That, I think, is the lesson for you.
Okay, thank you very much, Mr. Henderson. Given time is running out, maybe we can have Mr. Chong, would you like to give your thoughts on the question as well before we...
Well, yeah, given the time constraint, very quickly, I think it will be a great opportunity for any young lawyers, like Alastair said, to showcase their innovation and to showcase their creativity in showing the way to all of us, all practitioners, a new way of doing things so that we can overcome this problem that we are facing now.
Thank you very much. Just one final question from me before we close this off. How are you managing your physical distancing so far? Any tips for SIAC users, or perhaps best thing that you have watched on the streaming services besides our training video? Mr. Landau?
Actually, I have done nothing during this entire period other than watch the SIAC training video. Yeah, I highly recommend it.
Thank you very much. Professor?
And I believe Toby Landau.
All right. I think we are running out of time here, so we have to finish the session. I just want to thank all the speakers very much again for sharing their invaluable thoughts in this webinar. I'm sure the discussion would be very useful to many who are involved or potentially involved in an arbitration in these times. I also want to thank all the audience. So many of them are joining and participating in the discussion. Just reminding that this is only the very first session in the whole series of SIAC webinar. And the next one is actually in 2 days at the exactly same time. So that would conclude our session. Thank you very much again. Take care and stay safe, everyone. Thank you very much. Bye-bye.
Thank you.
Thank you.
Thanks. Bye-bye.
Thanks, everyone. Bye.
Bye-bye.